chickadees. Happy Wine and Crime Wednesday. I have been spending the past week basking in the glory of the amazing conversation I had last week for Wine and Crime Wednesday with the amazing Beth Karras. If you missed that, boy, you need to take a peek and go back and watch that interview that or conversation, I should say, that she and I had. It was amazing. She is a plethora of information. I had a fantastic time, and I am looking forward to she and I doing it again in the future. And I had a couple things pop off in the past week in the law and crime, true crime arena, and I felt I needed to use some words to talk about it. So if you're just coming in, thank you for joining me. If you're watching on the Twix, thanks for watching. If you're on replay crew, drop me a comment. I love to get the comments. I always try to respond. And let me say hello to some people. Also tell me in the chat what you're drinking. I'm two-fisted tonight. I am a Dr. Pepper Zero Sugar tonight because I just woofed down my dinner that Mr. Demeanor made. But I also have the backup water, because I think I'm going to be doing a fair amount of talking tonight, if you know what I mean. I hope you're all having a great week. I'm having a great week, kind of a busy week, but that's okay. I would like to tell you, rehearsals for the musical are going very, very well. I'm actually getting really excited now because this is the time when scenes start to come together and people are really starting to understand their characters and how they want to portray their characters. And so it gets really, really fun. This is my favorite part when you've rehearsed enough that you kind of know what's going on and now you get into the nitty-gritty of it. This is the best part. So I'm very excited. They're going fantastic and I'm exhausted all the time. But hey, I can sleep when I'm dead. So let me say hello to some people. Looks like Christine popped in earlier today and said hello. Thank you, Christine. Anne is with us tonight. Hello, Anne. Peppermint PJ coming on back, and Hope is drinking Pepsi with us tonight. Thank you so much. And I believe, and I don't know who it was, I had someone in my live stream on last Wednesday, that was celebrating their 6 months as a member, and I missed it. And I am so sorry and so apologetic. I was trying to use the best time with Beth because I knew I only had 2 hours. I didn't want to go too far past 9:00 p.m. for her. And so, I kind of ignored most of the chat as far as putting it on the screen or anything. So my apologies. When I do conversations like that, I generally do kind of focus on the individual that I'm having the conversation with and less on the chat. So my apologies to whomever it was that is now a full-blown chickadee instead of just a little baby chick. Thanks for being a member for 6 months. There was something else I was going to share also, and it escapes me now, of course, because that's how things always are. When you need the information, it's not there. We are going to talk tonight about the Karen Reed case. And y'all know I've kind of veered away from the civil case because I know it's going to drag out until 2034. And so I haven't gotten terribly involved in it. That being said, there seems to be a judge in Massachusetts that is not just a bit, seems to be rather salty about social media, rather salty about content creators on the tubes of you. And I thought, well, this seems like this is a challenge since he's making such a big deal about this. Don't threaten me with a good time, Judge Gildea, because we'll cover it now. I wasn't going to, but since you have such a problem with all of the media attention, social media, and YouTube content creators, I felt compelled that I must cover the last month or so of hearings. So there are a lot of things going on in the Karen Read world. I am doing my best to try to navigate all of those different things. There is a lawsuit against the city of Canton, if I am correct, because of the behavior of one Michael Proctor. There is a civil lawsuit by the House defendants against Karen Read for witness intimidation, and basically, we just don't like you. I mean, I'm sure there's actual legal grounds that they've put in there, but the truth of the matter is they just don't like her, and so they want to sue her. And then there's a countersuit back from Karen Read to the House defendants. And then there's a federal case that I'm not even really sure what all is going on in that one. It's all, this is part of the reason I could live and breathe in Massachusetts and never ever leave the state. It's like the gift that keeps on giving. So I have kind of stayed away, but I felt very compelled to cover Judge Gildea. Your Honor, you don't like us in the content creation world. You don't like us on social media. So hello, sir. We're going to cover it a lot. So I'm going to kind of jump around a lot this evening because I feel like we kind of need to. There's no rhyme or reason to this. It's Massachusetts, y'all. And this is not the part of Massachusetts where the lovely Beth Karras is from. Because remember, she's from Western Massachusetts. This is Eastern. All the crazies are on the Eastern side, apparently. All right. First up, I want to start with the hearing that was a complete scolding by the judge to all of the 752 attorneys that are representing all of the parties involved in these cases for information that I believe was already available. So y'all can tell me what you think. We're going to play the hearing now. Let me get us all set up here. I don't know where I'm going to put myself this evening. Let's try down here and see how things go. And let me get it queued up to when old Judgy Poo is actually in the courtroom. All right, buckle up. We're going to hit it.
Session, please be seated.
Your Honor, may I proceed?
Yes.
Your Honor, for the record, Civil Action 2483 CB 0692. This is Paul O'Keefe, individually and as personal representative of the estate of John Joseph O'Keefe III, et al. Versus C&C Hospitality, LLC, doing business as C.F. McCarthy's, et al. Your Honor, with your permission, at this time, I will call the names of the attorneys in attendance and ask that they state that they are present for the purposes of the record.
Thank you.
Attorney Brillahante.
Present, Your Honor.
Attorney Horwitz.
Present.
Attorney Fell.
Present.
Attorney Buck.
Present.
Attorney Diller.
Present.
Attorney Beaton has been excused, Your Honor. Attorney Holstad.
By the way, while they're going through this long list, Alan Jackson looks torqued. I mean, and then when this all comes to play, I understand why he had the demeanor that he had.
Present, Your Honor. Attorney Shipley has been excused. Attorney Tang.
Present, Your Honor.
Attorney Bell.
Present.
Your Honor, Attorneys Little and Mason are appearing via Zoom.
Attorney Jackson's getting some free publicity as well.
Attorney Jackson.
Present.
Attorney Seligson.
Present.
And Attorney Rosenberg.
Present, Your Honor.
You can sit down. Thank you.
Here we
So
go.
thank you, counsel, for being here. I scheduled today to be in person because of the significance of what I was advised of last Friday, and because I find the quiet solemnity of the courtroom is a good reminder of the dignity by which courts are supposed to function.
No, sir. You wanted to make sure you did a big, huge splash so that everybody could see you and you could read your prepared monologue and not allow anyone to speak. Let's call it what it actually is, Your Honor.
One commenter describes how every high-profile case now unfolds in two arenas, one governed by procedure and precedent, and the other by pixels, edits, and algorithms, and how the courtroom has become content and the law has become a spectacle. I
It's always
recently
been a
held
spectacle.
hearing on a non-party motion for a protective order. I required the moving party to provide certain information. Such material was filed together with the motion to impound. A hearing that included the motion to impound was held on a Monday morning. I allowed the motion to impound during the hearing. The affidavits of the moving party and the attorneys were impounded. Following that morning hearing, I found that there was insufficient information to support a delay in the deposition of the non-party from going forward. However, I further found that given the claims made in the filings, I would delay making a final decision on the motion until later that day to give the non-party's counsel the opportunity to supplement the record before me. I scheduled the matter for further hearing that afternoon at 4:15 with the expectation that there would be additional filings. At 2:22 p.m. that day, the non-party's attorney emailed the clerk of this court and all counsel of record, excepting one, additional materials in support of the motion for a protective order. The filing included a motion to impound additional materials. Exactly 30 minutes after the email to counsel of record of the additional material, which included sensitive and private medical information, similar information to what was in the exhibits to the filing and marked provisionally impounded, was posted to an X account at 2:52 p.m.
Do y'all know what X account it is? I'm going to tell you since he keeps it a secret. I don't understand. If you want to make such a big deal about this, you dorkwad, then say what it is. Say who it is. Splash it all out there. Let's see what the heck is going on. Why are you hiding? Grant Smith Ellis. That's who posted it at 2:52 p.m. It was not impounded material. It was the material that was part of the motion. You doofus. Do you not even understand what goes on in your own freaking courtroom? Oh, this man. Talk about a spectacle. Your Honor, you're making a spectacle of your own courtroom. I'll try to keep my rants to a minimum, but this man has me absolutely rageful.
Upon learning this information, I ordered that the parties and counsel provide a certification to the court as to all facts known to them as to any dissemination to anyone other than parties and counsel in this matter of any of the contents of the material impounded on June 8, 2026, and I scheduled this appearance for today. I received certifications from all party and counsel, 32 of them in total. No one apparently has disseminated, nor are they aware of any facts regarding the dissemination of the
You
contents
don't
of
say.
impounded material to any person or entity other than
Really?
the parties and counsel in this matter. However, somehow,
Okay, Your Honor, what was disseminated was the item recorded by your very court. how you could have ever thought someone from any of the attorney's offices would have disseminated this information when it was perfectly clear that it was obtained through your own recorded filings. This man, is it because he's old? Does he not understand how technology works? Is that where we are here? Is that what's happening?
An ex-account holder, not part of this case,
And he won't say his name.
apparently
Grant
received
Smith
information that was
Ellis.
at least provisionally impounded.
Not at the time he got
Orders
it.
of the court have been violated either directly or at the very least in spirit.
And let me just tell you something else, as long as I'm on a ranting kick this evening. Nobody would have actually known whether it was true that it was private medical information until he did this. Thank you, Your Honor. We all know now that what was disseminated on X was absolutely correct and true. Way to go, bucko. You're just a real pillar of intellect, aren't you? What a dummy. I mean, what are you doing, Your Honor? Ah.
If these orders are to have any effect, all parties involved must operate with integrity.
Including you.
13C of the Uniform Rules of Impoundment Procedure imposes a duty on all persons to protect the confidentiality of impounded material. Additionally, Rule 3.6 of the Rules of Professional Conduct prohibits lawyers from making extrajudicial statements that they know or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. In cases like this, where all parties involved are aware of the public attention, I expect that everyone is taking every precaution to preserve confidential information, to follow the rules of the court, and to adhere to my orders.
You did.
Because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party.
I want receipts, timelines, text messages, screenshots. Like, I want proof, Your Honor. You're in a court of law. You ought to know that. He provided nothing. He just got up there and spewed some bovine scatology, and everybody's just supposed to go, oh, I'm so sorry. We didn't mean to upset or offend you, Your Honor. Oh, we're so sorry. He provided nothing.
If necessary, I am fully prepared to make such order permanent as permitted by Rules 26 and 30.
Which is insane, because that means they would literally not be able to get discovery. Ava Danielle, welcome back. I haven't seen you for a while. Wasn't there a timing correction filed? Thought I saw something on Defense Diaries last night, but I fell asleep, so it could have been a dream. So, okay, yes. I shouldn't say yes. I don't know that for a fact, but I do know that Defense Diaries had been following the timeline very closely. And if you want to see the actual post that Grant Smith Ellis put on X, I know they have it in their live stream from the day of this hearing. So feel free to check that out. We love Defense Diaries. And the fact of the matter is, even if there was a timing correction filed, he already did this. It's already done. You didn't allow anyone to speak so that you could have been corrected on the record for what your ridiculousness was. I want to know who told him. That's what I want to know, because whoever that was, they're an idiot too. Hey, Melissa, thanks for coming on back and hanging with us tonight. I'm a little ranty tonight, so prepare yourselves and buckle up.
To any issue counsel may raise as to the management of discovery issues being within my discretion, I invite you to look at the following cases. In the 2003 case of Buster v. George W. Moore, Inc., 438 Mass. 635, the SJC stated at page 653, in general, discovery matters are committed to the sound discretion of the trial judge. In a 2002 appeals court case, Mattoon versus the City of Pittsfield, 56 Mass. Ave. Court 124, the court stated at page 131, trial judges have broad discretion to make discovery and evidentiary rulings conducive to the conduct of a fair and orderly trial. In the 1987 case of Solomon A. versus B. Gruel, 399 Mass. 790, the SJC stated at page 799, the conduct and scope of discovery is within the sound discretion of the judge. In Cronin versus Strayer, 392 Mass. 525, a 1984 case, the SJC stated at pages 535 to 536, we remind judges that the scope and timing of discovery is within their discretion, and the prevention of discovery abuse is sufficient justification for the authorization of protective orders. With this authority at hand, judges should not hesitate to exercise appropriate control over the discovery process. And finally, in the 1987 case of Campagna versus the Board of Directors of the Massachusetts Housing Finance Agency, 399 Mass. 492, the SJC stated at page 503 that Rule 37 affords a judge broad discretion to impose whatever sanctions are just in order to ensure that the discovery process operates efficiently. The malicious publication of private information concerns me. Whatever opinion that one may have of a non-party, even if warranted, such an opinion does not allow
It
for the
wasn't an
disparate treatment
opinion.
of such individual. All people deserve fair and equal treatment in our system of justice, regardless of any personal characteristic, as abhorrent as some of them may be. What I am looking for is for the parties is adequate assurances that their discovery served justice and not any desire to weaponize the rule for pettiness and profit. If the parties and lawyers would enter into an agreement to hold private, personal information in confidence, and if the terms were acceptable to me, I would consider entering it as an order of the court so that any violation would be grounds for a contempt finding and appropriate sanction, including dismissal or default. Such an order would need to be more than a stipulation that deposition testimony can only be used for the purposes of this case. I encourage the attorneys to confer and to seek to reach an agreement. In the absence of an agreement, I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery. While you are conferring and seeking to reach an agreement, I will again remind you, as I have quite often, that the discovery clock is ticking.
Your Honor, maybe we need to take a little history lesson in how you've conducted all of the endless status conference hearings in which you continually kick the can down the road. Do we need to talk about that? Let's talk about the timeliness of discovery, Your Honor, because as a gatekeeper, you suck. Like, really suck. There is no way. I've watched several of these hearings, and this is part of the reason I hadn't been covering it closely. Status hearing. Did you get to the depositions? Did you get the depositions? No, they won't answer our subpoena. No, this one's running from our subpoena. Did you do the deposition? You're supposed to do the depositions. Oh, you didn't get any of the depositions done? Oh, you only got 3 of the depositions done. Okay, well, let's meet again in 3 weeks. What are you doing? Take charge. Take charge. These people are trying to avoid depositions. Make them appear. That's what I thought a subpoena was for. Apparently not. Not in Massachusetts anyway. Oh, I'm so rageful about this. I camper for life. I'm so rageful. I'm so sorry to all of you. I am sick of Massachusetts and the mess that they create of every legal proceeding. It's boggles the mind. Absolutely boggles it. All right.
My final request to council with an appearance in this matter is to familiarize yourself with Rule 3.6 of the Rules of Professional Conduct relative to publicity. The rule sets forth a basic general prohibition against a lawyer's making statements that the lawyer knows or should know will have a substantial likelihood on materially prejudicing an adjudicative proceeding. The rule applies to lawyers who are or have been involved in the investigation or litigation of a case and their associates. As the comment to the rule notes, it is difficult to strike a balance between protecting the right to a fair trial and safeguarding the right of free expression. However, preserving the right to a fair trial for everyone necessarily entails some containment of information that may be disseminated prior to trial, especially where trial by jury is involved. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence.
What is forensic decorum? I'm going to side quest that because I think he's getting to the part where he tells everybody that he's going to shut everything down and seal everything for, I think one of the motions is sealed for 30 years. It's unbelievable. This guy he must have bumped his head or something because this is crazy.
The rule takes into consideration that the public has a legitimate interest in the conduct of judicial proceedings, particularly in matters of general public concern. However, I'm not so sure that churning the waters to generate social media coverage necessarily can result in a legitimate interest in the conduct of judicial proceedings.
Hi, Judge.
Read the
We're
rule,
churning the
especially if you've
waters.
never done so. Adhere to it. We'll be ready to face the consequences for failing to do so.
Bring it, baby. What
I
consequences are you going to give
remind
me?
counsel of what one
Last I knew it was a free
commentator
country.
called the quiet expectation of fairness that we have as citizens. Such expectation is based on the framework the founders of our country built 250 years ago and trusted future generations to maintain. Counsel, do your part to maintain the quiet expectation of fairness.
How about you do
not
that
succumb
too?
to the attraction of seeking to influence this case through social media.
You should have said
Read what a
Siren
trial
Song of
lawyer should
Celebrity.
One that tries their case in the courtroom. And remember the provisions of General Laws, Chapter 221, Section 28, relative to the oath of office for an attorney in Massachusetts, which provides, in part, I solemnly swear that I will do no falsehood. I will delay no man for lucre or malice, but I will conduct myself in the office of an attorney within the courts according to the best of my knowledge and discretion, and with all good fidelity, as well to the courts as my clients. So help me God.
So help me
I
God.
wish all of you a
We're gonna
happy
record
4th of
everything.
July on the anniversary of our America's 250-year-old democracy. May it continue to succeed with all of us working to maintain the rule of law. Thank you.
Court, all right.
For the record,
And then he leaves. He just leaves. He's like, deuces. I'm out of here. I said what I said. That's right. Said what I said. When I heard this, I didn't hear it live, thank goodness. I listened to it on my drive into work, and I was dumbfounded, baffled, my jaw dropping. By the way, forensic decorum, for those that want to know, I looked it up because that's how I roll here, refers to the professional conduct, etiquette, and ethical behavior expected of forensic scientists, legal professionals, and courtroom participants to maintain credibility, respect, and trust. So you've all learned something new, unless you already knew that. If you already knew that, kudos to you. I did not know what forensic decorum meant. Because forensic to me means something in the past that you're researching. Decorum obviously is behave yourself and, have proper decorum. That was a new one to me. Forensic decorum. So that's where we ended up. I'm going to go back in time now because there were some other hearings that led up to this hearing. There were some documents that were filed that also led up to this hearing. So we're going to kind of bebop around a little bit. I have thankfully gotten permission from the Young Jerks to use some of their content that I may be using later this evening while we cover this. So I very much thank Mike Crawford at the Young Jerks. It was very kind of him to allow me to splash his live streams here. Yeah, the judge has none of the forensic. I'm going to start using that phrase all the time. I say things to my husband now, may it please Mr. Demeanor. He's like, what? I'm like, oh, sorry, courtroom talk. I was at rehearsal last night and someone asked a question and the director goes, I'll allow it. And I went, excuse me. You must say, I'll allow it, because that's how we know it's said. So I'll be adding forensic decorum to my vocabulary. Also thought I saw something about Proctor's attorney being the leak. They are blaming Turtle Boy. Of course, crazy. Well, of course they're blaming Turtle Boy because that's the easiest thing to do. Turtle Boy isn't the one that spilled the beans. Did he have intel and told everyone, hey, this is what I'm hearing from a source? Of course. It wasn't any private medical information. Give me a dadgum break. Now, Turtle Boy didn't do anything wrong in this situation, so they can all go fly a kite. Hey, Granny Debbie. Happy that you made it back with us. Okay, so the next thing I am going to share before we get into some documents, also, this just flew into my head, something else that I have watched over the past week or so. There is a television program called Celebrity Crime Scene, and they did Marilyn Monroe's death. Y'all need to check it out if you haven't already. Very cool. I know you all like to go visit the actual crime scenes, and they do a complete AI mock-up of Marilyn Monroe's bungalow that she lived in when she passed away. So, check it out. It's pretty cool. Right now, we're going to go to a different...
Good afternoon, everyone. Can you hear us?
Sorry, I didn't mean to do that to y'all. This is a different hearing. It took place on... Well, it was about a month ago. So this would have been the early part of June. And let me get us set up. Oh, Ava Danielle, it's awesome. You need to go check it out. Seriously. It's not a very long program. Very fascinating. The forensic, I can't remember her name. She had a television show. purple hair, very attractive. She is one of the people that kind of walks through the case. Super fascinating. So all of my people that like to see the original crime scene, got to go check that one out. All righty. You ready to all hit it? I got to figure out where I got to put myself. I may have to just take myself off completely because I think this is a Zoom. And so we've got people all over the place in boxes. So let's see what happens.
Yes.
Great. Give me 1 second while I get the camera situated. Are we expecting any other counsel to be present with their camera on? I know I have some counsel that's in.
Side note, does this lady right here, does she totally look like Helen Hunt? Is it just me? She looks like Helen Hunt to me. I'm just like freaking out. I'm like, is that Helen Hunt representing someone?
The waiting room, but or the as attendees, but they declined to turn their camera on. No, we have everyone? Okay.
No one else for waterfall, Madam Clerk.
Thank you.
Thank you.
Ah, there he is.
May I proceed, Your Honor?
Please.
Your Honor, the next matter before the court is civil action number 2483CV00692, Paul O'Keefe, individually and personal representative of the estate of John Joseph O'Keefe III et al. Versus C&C Hospitality LLC, doing business as C&F McCarthy's et al. Your Honor, for the plaintiff, O'Keefe's, we have attorney Daniel Buck and attorney Mark Diller present by way of Zoom, as well as for the defendant, we have C&F McCarthy's, we have attorney Tamara Holstag and Lincoln Rose. For defendant Waterfall, we have attorney John Deely. For the defendant Reed, we have attorney Damon Seligson and attorney Aaron Rosenberg.
Good afternoon, everyone.
Good afternoon, Your Honor.
So at one of our recent status conferences, there had been one deposition that had been conducted. I think the last time we got together, there had been 2 depositions conducted. So I'm hoping there have been at least 4 conducted, but I guess I'll have to find that out.
I hope
so
you
why don't we
are going
start
to
with
learn
Attorney
to live
Diller
with
on behalf of the
disappointment,
plaintiff.
sir.
What
Yes, Your Honor.
depositions have been taken?
We've taken all 3 of the depositions that have a date, Your Honor.
So there have been no additional depositions since we last got together?
We took 2 depositions since we last got together. Some of the depositions that were also noticed had been canceled.
Canceled, you say?
Okay. What depositions do you have noticed that haven't taken place?
We have 12 additional depositions noticed that haven't taken place. One of which we had a meet and confer with the Reed team regarding the deposition of Paul Mikowski. We're trying to figure out whether or not we need to move forward with that deposition or whether that's going to become an issue that's live for trial. We also were asked to take the deposition of Karen Reed off for the June 19th, and we're trying to put that on for June 24th, Your Honor.
Attorney Rosenberg, why does that deposition have to be taken off?
Well, because June 19th is a federal holiday, Your Honor, and multiple offices are closed.
Duh!
So we're not, first of all, it was noted.
Are we for real right now? This man is an officer of the court. You do not know that June 19th is a federal holiday? What world am I living in? I think I'm starting to hear clown music. I hear the circus. I swear. What is happening?
first in, I believe, mid to late July. And then Mr. Diller renoticed it for June, which is fine if the date's available. But he picked a date where offices are closed and it's a federal holiday and we are not available. We are fine with rescheduling.
I wonder
In fact,
how many, I wonder how many of the attorneys on the Zoom call have their offices open on that day?
I don't know the answer to that, Your Honor, but I know it's a federal holiday, and if one party determines that they're going to hold a deposition
Your
on a
Honor?
federal holiday and the others aren't available, that seems relatively reasonable to me. As I was saying, though, we provided additional dates.
Hang on, Attorney
Your Honor, you're not going to be working on June 19th. So why would you make them?
Rosenberg. Just keep in mind in all the discussions we're having today, the context of this case and where we stand and how long discovery has been ongoing and how few depositions have taken place. That's the background that I'm coming from. So it wouldn't surprise me if an attorney would decide to take a day that would be open for most people to conduct a deposition. But your office is closed, so that's fine. I guess it's not going to go
Apparently
forward on
it's
that
not.
But also, respectfully, Your Honor, the case has been going on for different parties for different lengths of time.
Yes.
My clients only had active discovery pending for a year. Mr. Diller chose one date and then rescheduled to another date. And the second date he chose happened to be a federal holiday. We proposed 4 other dates earlier than what Mr. Diller had first chosen, and we are willing to reschedule it.
Mr.
The only
Rosenberg.
reason that date doesn't work is because of the particular date that he chose. So we are happy.
So what dates do you have before June 19th?
Before June 19th, I believe we don't have any because the vast majority of them are taken up with scheduled depositions.
Now they are because you decided not to do it on those dates.
And this isn't directed just to you, Attorney Rosenberg.
Is this man dumb? I'm really, really struggling. Y'all. Okay. We need to talk. Y'all and me need to talk. Because I've been having some things happening in my life recently. And I'm starting to think that I am either the most intelligent person that most of the people that I spend my time with, or that I watch on TV, or that I watch in law or anything. I am either that, or there's a lot of dumb people in the world. Because why is this judge not able to figure out that those dates are no longer available? We offered them up. He said no. Diller said no. And now we've filled those dates with other things going on. It's not that complicated, Your Honor. Judge Gildea, are you with us, sir? Are you with us? Because I feel like you are not tracking. Like we're all and you're like, sir, time to get with the program. Oh my word. For the love of Mike.
But it's just beyond belief to me, the number of experienced lawyers involved in this case, the length the case has been pending, for however long it's been pending for all parties, and even if it's only been pending for Ms. Reed for a year, that there are so few depositions that have taken place.
Can I address that?
No, Attorney Rosenberg. I don't need to hear all the details. I don't need to hear the nitpicking that someone canceled the deposition, that they put it on a holiday. With all due respect, I don't need to hear that. What I need to hear is, going forward, how you're going to get the discovery done.
Oh my. I had no idea this particular hearing was going to enrage me as much as it has. My apologies for stopping yet again. But as someone that works in management, if you don't happen to like the tenor of your office, in this case, it would be your courtroom, sir, change it. It's your courtroom. Fix it. Fix it. Tell them this. Tell them when it has to be done by, or they don't get it. Why is this man incapable of actually setting a deadline and making anyone follow through on it? I don't understand this at all. I would be so rageful right now. This is why it's a good thing I didn't go into law. See, there's reason for everything, because I would be like, well, actually, no, I'd like on the record why, and then I would go on. Hey, Jillian, thanks for coming on back. I'm just raging and ranting tonight.
That's what I'd like to address. That's what I would like to address.
Go ahead.
So I just want to give you an example, and I'm not looking to nitpick your.
I don't want to hear. I don't want to hear an example of what happened. I want to know what's going to happen.
Well, that's what I'm trying to explain to you, Your Honor. If you'd let me just say that. So, for example, we had depositions of the following 6 individuals. Notice,
Attorney Rosenberg, I don't care what has happened now. All right.
No, I'm talking about in the future.
It's obvious that the parties are having difficulty working together. So what I want to hear from all of you is what you're going to do to get this done.
That's
so
what I'm
tell
addressing.
Me what you're going to do to get this done from your perspective.
That's what I'm trying to address, Your Honor. If you would please let me explain. We have.
If you'll shut up, Your Honor, I'm going to explain what we're doing here. But you see, sir, you won't shut up. You just gonna continue to dress me down. What is happening?
6 depositions that are currently scheduled in the future for the following 6 individuals who are major witnesses in this case from my client's perspective. Brian and Nicole Albert, Jennifer McCabe, Matthew McCabe, Allie McCabe, and Brian Higgins. They've been noticed and subpoenaed for a month. Last night at 9:35 p.m., we received an email from the single attorney or firm that is representing those 6 individuals telling us none of them are available for the dates on their subpoenas. And with one minor exception, none of them are available prior to July 20th. So respectfully, that it's not nitpicking, I believe, to say that the reason that we've had trouble taking depositions in this case is because this is not the first time that the witnesses have, in our view, played games with the scheduling. And so I'm not interested in coming to you every time this happens, Your Honor, but if you want to know why we are struggling to take depositions, it's because third parties are not showing up for subpoena deposition dates. And there's already one motion to compel that has already been served as to the first of those witnesses that you will receive probably in a week or so. And once we confer on this email that came in at 9:35 tonight or last night, unfortunately, it appears you're likely to see a number of other motions to compel on this. And we will, per your instructions in the past, we will do that quickly and we'll get them to you as soon as we can.
So a valid point, but answer this question for me. What was the date that those individuals were first noticed for deposition?
A month ago!
The 6 individuals that I just listed?
Yes.
I don't know off the top of my head. I know their subpoenas were served a month ago.
I bet Attorney Seligson probably is pulling it up on his computer right now as his eyes are casted downward. So maybe he can let you know. So a month ago. What's that?
I'm doing my best to get you that information, Your Honor.
Okay, thank you.
This judge is insufferable. Can you, this is like some of the people that we have watched testify or we've watched on body cam and we're like, oh my gosh, this person's insufferable. That's how this judge is. He said it was a month ago, but I will laugh so hard if it ends up being more than a month ago.
So a month ago, those people were first noticed a month ago.
No, subpoenaed, Your Honor. I
They
said
were-
subpoenaed. I said I
yeah.
don't know off the top of my head when they were noticed, but they received
So before
subpoenas a month
that.
ago for their depositions that are supposed to be in, I believe, in the next week or two. So that's about, what, 5 weeks in advance?
So I guess you're all going to have to engage in motion practice if you can't get people to show up for depositions.
No, Your
Agreed.
Honor, you compel
right.
them to. That's within your
So you have
purview.
6 depositions noticed. You have any others than those
Oh,
you
yeah,
just
we have,
mentioned?
yes, Your Honor. We have, so this Monday, we have the deposition of Michael Proctor. We had a deposition scheduled for the 10th, which is one of the ones I just described to you. We have I don't need to go through each of them, but yes, there are additional depositions we have beyond those folks. I believe probably 3 or 4 more, including the plaintiffs.
When are the plaintiffs available for deposition, Mr. Diller?
They're currently scheduled the beginning of next month.
They'll figure out a way to evade it again. I had to put Bizarro World up. Y'all, I haven't had to do Bizarro World in a really long time. We're officially in Bizarro World because none of this makes any blessed sense to me.
And Attorney Diller, what depositions do the plaintiffs have noticed in addition to what has been talked about?
We've noticed Karen Reed, Caitlin Boudreau, Aiden Carney, Janet Reed, Nathan Reed, William Reed, multiple witnesses from C.F. McCarthy's, multiple witnesses
The Cole of
from
Keithises, I'm sure.
Waterfall. And
Better be nice to the Colakeithuses.
we have an outstanding deposition that we had scheduled for last week that was canceled by the Reed team based on a meet and confer, and we're going to figure out whether that has to go back onto the calendar.
So with respect to the people from McCarthy, did you consult with Attorney Holstag before you scheduled them?
We have been in constant communication, Your Honor, yes, and multiple witnesses that I just mentioned had private counsel that is not the Reed team here. We had coordinated dates with them based on that outside lawyer's availability together with the availability of the deponents. So those dates were scheduled in a meet and confer with the counsel who represents Karen Reed's family, which is not the Attorney Reed's team here today. So we met with them and set dates based on what they told us their availability is and based on everybody's availability. It's worth noting, Your Honor, and I appreciate the concern that this court has, and it's equally a concern, but to date, there have been 27 canceled depositions, of which
I don't want to hear people pointing fingers or any of that stuff. It's just not productive.
I hear you.
So let me ask Attorney Daly and Attorney Holstag, I assume your employees or company representatives, you've consulted with whoever wants to depose them and you've indicated when they'll be available. Are there other people that you seek to depose that you have noticed and you're having difficulty with? Attorney Holstag?
Yes, Your Honor. Yes, in answer to your first question, we've been in consultation with Attorney Diller and his team. We are making our folks available, and the first of our witnesses, one of the co-owners of C.F. McCarthy's, was deposed last Friday. In addition, the folks that we intend to depose would be, of course, the plaintiffs that brought suit against C.F. McCarthy's. And then we have some witnesses, third-party witnesses that were present at either our bar the evening in question or at Waterfalls. Two of those witnesses that were at Waterfalls were noticed for deposition today, and subpoenas are going out
Waterfalls?
today.
Is this like the Myers and the Kmarts and the, what's the other one I hear all the time? The Walmarts and I thought it was the Waterfall. Are there multiple waterfalls? I thought it was just one. This is right up there for me with the people that can't say like STR. Sorry, another rant I'm having. STR, like string or street. And all of a sudden, everybody that I hear saying it, it's like they have some slurring speech. It's street and string. And I don't understand what's happened to our society. It's string, street, strip, stripe, not strip, stripe. Like, if you want to talk like that, go in your garage.
Attorney Daly?
Good afternoon, Your Honor. In addition to people that are already noticed by other parties, Your Honor, we have 3 witnesses that are noticed for deposition in July, who again were bar patrons of one bar or the other, as well as the state police toxicologist, Your Honor, involved in the Karen Reed investigation.
And when is that last deposition scheduled for?
The state police toxicologist is scheduled right now for notice for July 10th, Your Honor.
Is there a difference between noticed and scheduled?
No, Your Honor.
Your Honor,
Apparently there is.
Pardon.
Go ahead.
Just to add one other thing, Your Honor. The other owner of CF McCarthy's is presently scheduled, and we've conferred with Mr. Diller for July 2nd.
Oh, Helen Hunt has more to say.
Were the 2 owners, were they there that night?
One was.
Way to be on top of things, Judge Gildea. Woohoo! Way to go.
What, if anything, can the court do to help the parties other than to act expeditiously on any motions that may come before me?
You can compel them to sit for their depositions.
That's all from our perspective, Your Honor.
We'll involve the court with some of the issues that we have outstanding and ask the court's indulgence to act expeditiously.
Mm-hmm.
So what motions have been sent out under 9A and can I expect to receive shortly?
From us, from Ms. Reed, Your Honor, I believe the only pending one right now is a motion to compel production and deposition of Colin Albert. Then there is, I believe it's likely that you'll see similar motions relating to the 6 other individuals that I listed.
Yes. Oh, Colin. Our
But we
military
just found out last
man.
night that they're apparently unavailable.
I didn't hear the last part of that. Attorney Rosenberg, I'm sorry.
As I said earlier, we've only just found out last night that they're apparently unavailable, so that motion hasn't been served.
Did the notice of unavailability indicate any reason or other than they just can't be there?
It says, with respect to the depositions, our clients are not available on the dates proposed in the subpoenas. And then their availability is as follows, almost entirely July and late July and August. That's it. So we'll confer and try to work that out and get them sooner than that. But if not, you should expect those motions.
Attorney Seligson, did you find the date when they were first noticed?
Yes, Your Honor. They were noticed. The depositions went out on May 5th for various dates in June and May.
And Attorney Rosenberg or Attorney Seligson, how did they get kicked over beyond that? Because it's June already.
Those are the dates that, so Colin Albert refused to appear and refused to produce documents, said his attorney said he was unavailable, and then out of the blue said, now he's only available for another 7 days, and then he's gone for the rest of your discovery period. So that was that deposition.
All right, everybody. Y'all let me know, but does it seem odd that you would be a party in a civil lawsuit and think that you are not going to be deposed in the matter? First off. Second off, when you are initially requested and then subpoenaed, which is, as far as I knew, a demand for you to be deposed, that you would for some reason come up with a million excuses as to why you cannot appear for the civil case that you began against another individual. Does this sound like behavior of people that have nothing to hide? Just a question. Just a question. The Alberts and the McCabe's, I don't understand if you don't have anything to hide. Why are you trying so hard not to be deposed? And Colin, why the heck is he trying to do? I mean, he's gone into the military to avoid it. I don't know if that's the reason why he went in the military. I'm just saying. That's why I think he went into the military, so he wouldn't have to be deposed. Because there's something stinking. Something stinking. Granny Debbie says, I want to know why the judge went from appearing to be helpful to his current state. Well, I'm sure there's a significant backstory on that one. We'll continue on. It's very suspicious behavior. Why are you trying to dodge the depots? They're depot dodgers. Oh, it's like draft dodgers, only they're depot dodgers.
The other ones are the ones that I've been referring to today. They've gotten kicked out because we just found out that they're apparently unavailable.
It's good to hear that someone's paying attention to what the deposition discovery deadline is. I'm sure you all are as well, and I anticipate there are going to be motions forthcoming.
That was so funny.
Nothing's guaranteed here.
From our perspective, Your Honor, all we're trying to do is get it done in the current deadline. I mean, we're with you, and that's why the dates we got last night aren't workable, because it's going to jam everyone up on this call unnecessarily. So we'll try to figure it out. If we can't, we'll bring it to you quickly.
Your Honor, I don't agree with what has been created as a record here today, but I'm not looking to get specific unless this court wants me to, but I just want to say that I don't believe that what was created as a record here for you today is an accurate assessment of how things have transpired.
Oh, really?
Notably with the Colin Albert deposition,
oh, really?
As well as with some of these other ones.
Do tell. He didn't want to get into the details.
Well, I know that because we conducted the deposition of Colin Albert last week.
You did?
And what had happened originally was that deposition was scheduled in February. It was noticed in February. We blocked the time to have it occur in late April. There was never any subpoena. So that's why I'm using the distinction between a notice of deposition to us, and we were of the
look at Rosenberg. He's like,
professionally, that we were going to block our calendar and prepare for those depositions, to which we did. That deposition was supposed to take place, I want to say, on or about April 29th. At the 11th hour, that deposition was canceled.
Scheduled?
And I'm told it was canceled by the Reed team. Then it was never renoticed or put back on the calendar. Sometime on...
hang on, Attorney Diller. I'm sure at some point in the future, I'm going to be asking, in response to requests for more time, exactly what transpired in the past relative to various prospective deponents. So I'll have a chance to look at all of that. But, and again, I don't mean to be dismissive, and I hate to use the word nitpicking, but
You don't want to hear
I
the
just don't want to hear it at
details.
this point.
Yeah, you don't want to hear any of it.
Pointing fingers. So
You just want to come up here and be like, oh yeah, everybody hurry up, do what you're supposed to do. Okay, great. Let's kick the can down the road. Because if you had a pair, you would actually make things happen. But you don't, and so you don't. This is the most ginormous pissing match I've ever seen. Take control of your courtroom. My word.
what productive things can we talk about today?
I don't think anything. You won't let them.
Let me ask this question. Are any of the counsel on the Zoom call, do they have scheduled vacations that are going to interfere with
for the
completing
love of
discovery?
Mike.
No, Your Honor.
No, Your Honor.
No, Your
Okay.
Honor.
No, Your Honor.
Because I know I made a comment about you ruining your own summers, but I'm not here to ruin someone's pre-planned vacation. But hearing that there are none, that's good. So now we can
What do
keep
you
moving forward.
care? Don't try to be human now.
What else does anyone want to talk about today?
Oh my word. Rosenberg is like, I am over
All right,
all
so
of
let's
this.
pick another date.
Okay.
Go ahead.
Well, nothing. You had just asked earlier, but we can table that and you'll see it forthcoming
loves
that
to
there'll
table
be some
things.
motions in the near future.
So what are those motions, Attorney Diller?
Well, I can tell you that as of now, we served a motion to compel, we have a keeper of records subpoena outstanding with Aiden Carney. We also simultaneously and concurrently filed a motion to intervene in the criminal court to get access to materials that are reasonably calculated to lead discovery of admissible evidence in this case, in the Aiden Carney criminal matter. We have that, those subpoenas were outstanding. They have lapsed. We've never heard from Mr. Carney, but we're confident he's received them because he's gone extensively on his program and talked about his receipt of our subpoenas.
Okay,
So-
but that's the criminal case, right?
Yeah, talk about getting off topic here. And by the way, I don't blame Aiden for not wanting to appear for these depositions because as crooked as everything is, I'd be terrified. I would be terrified. But also, I wouldn't be on my YouTube channel yapping about it because that's part of the problem. Zip it. Zip it, dude. I mean, nobody's going to listen to me. I'm just a middle-aged lady in America, so, you know. But what on earth? You just went on a complete rant about a party that really doesn't have anything to do with any of this. So talk about pandering to social media. Shut up, Diller.
No, we subpoenaed him as a keeper of record in this case. We also simultaneously sought to go in through the criminal case and subpoena the Norfolk District Attorney's Office. There may be
Okay, so
overlap, there may not be.
in the case that I'm involved in and I'm overseeing, if you subpoenaed something and you didn't get what you wanted, file a motion. all
That's
right? And
pending.
we'll put it on for an expedited hearing.
Yeah, we've served it 9A, Your Honor. So I just wanted you asked to tee that up, and I just wanted to let you know.
Okay. Anyone else? Attorney
They're all
Buck
like,
and Attorney Rose, you want to get out of this without saying anything?
Happy to say good afternoon, but with this group, less is often more.
Second that, Your Honor.
All right, so let's pick a date.
pick a date to kick the can on down the road again.
Are there any
Not-
depositions scheduled on June 30th?
Yes.
How about June 29th?
Yes.
Yes, Your Honor.
I guess I could say June 19th, but I know the court's not going to be open.
No, you won't be working, sir.
So how about
Dummy.
July 1st?
Oh.
Yes.
Deposition.
I already heard July 2nd is one scheduled.
Yes.
I won't torture you and ask about July 3rd.
I think we've got one scheduled, but
We've got depositions scheduled on July 3rd.
How about June 26th?
I'm not available.
well, we have a deposition scheduled currently. That's one of the ones that may be subject to a motion to compel.
Okay, so someone look at their calendar and figure out someday in the second to last week of June that there's no deposition scheduled.
25th.
25th?
I'm not. Okay. I won't be available. I'll see if somebody else on my team will.
We're not going to keep going through them trying to figure out their butt from a hole in the ground. So, but Granny Debbie, Ms. D, not sure if you'll get to it tonight, but you will flip when you see what information they are requesting from Karen Reed. Well, if you can point me in the right direction, I have several documents I was planning on covering. I'm not sure which one you are referring to. Let me see. This is the first amended complaint. This was on June 5th. Is that possibly what you are referring to? This is the actual complaint. Is it a motion to compel? Help, point me in the right direction as to where is this demand being made, and I will see if I can get the document for it, because I will go check on my friends on Discord, Seeking Justice. They're awesome. We love them. And they have all kinds of documents for us. Let me see if I can get anything pulled up here. I am not the most well versed in the world of Discord, so bear with me while I try to find what the heck I'm doing. I thought I kind of I thought I had kind of reviewed what was available and I didn't see anything. Let me go back. I'm trying to find where the documents are because, you know, you have to find things in a weird way in Discord. I'm still looking. Bear with me, folks. Documents, Massachusetts State Police, Town of Canton. Is that where it is coming from, Granny Debbie? Let me look at the documents here. Defendant, summons, complaint. I don't think this is what you're looking for. One of the latest filings, and Karen's team filed a response. Well, I'm not seeing it here. Let me take a peek. I'd like to get to right straight to the documents part of it, but I don't know how to get there. These are pinned messages. That is not going to help me. I am, Little Drummer Boy, I am looking for the latest filing where they are requesting Karen Reed provide specific information and what that is. So I'm assuming it is a motion, but I'm not very good at finding it right now. I thought I had some of the most recent filings. This is from Karen Reed, and this was filed on 6/17. So it's not that one. It's got to be something more recent than that, something in July, and I am just not seeing it. It could be the interrogatories. Yes, it could be. I'm not sure. While we're trying to find that, let me share something. I think everybody remembers seeing or hearing about the thumb drive and how damaged it was and such. While I was doing some research and looking at the documents, I stumbled upon this particular exhibit as part of one of the motions. Let me make it big for you. This was what the USB thumb drive came in. Okay, that's not too bad. Looks like a U.S. Postal Service. Odd that there's plastic on it. Oh, Lord, what happened on this side? Right? Isn't that what you said? It looks like somebody drove over the stinking thing. And then look at the inside of it. It got worse. Like, how did you send it like this? And then here's the actual thumb drive, and you can see it's got damage on the actual thumb drive. What? Look at that. I remember this coming up in, I don't remember if it was season 1 or season 2 of Karen Reed, that they were unable to get. They got the thumb drive, but it was damaged. Fortunately, it looks like they were able to get all of the information off of the thumb drive. I just had to share that because when I saw that, I was like, whoa, that's something. Let's see what else we can go through. I have the complaint about all the Proctor stuff. All the things, his text messages and what he said. Y'all let me know in the chat if you want to delve into that. I don't know how interested I'm in that because there's lots of very disgusting and vile things that are in these text messages. But I do have it pulled up in case anyone is interested. And I have the first amended complaint, the memo to compel further answers. Point me in the right direction to where it might be, Lil Drummer Boy. Yes, motion to compel regarding interrogatories. If I can't get it on Discord, I'm probably not going to find it because I don't know how to access the court system in the Massachusetts. Hey, KS Granny. Thanks for joining us. We're just doing a little bebopping around trying to find some recent documents on Karen Reed. The last thing I see posted in this thread on the Karen Reed John O'Keefe is from June 30th. So the link you sent is directly to the document. Did you email the link to me, Lil Drummer Boy, or did you Twix it to me? See all. Oh, well, will you look at that? This is a little easier. Lawsuit. This was 30 days ago. Oh, federal lawsuit 4 hours ago, 3 hours ago. Let me see where you sent this. Aha! You twixt me. I gotcha. All right. Let's see what happens. It's thinking. Thank you all. See, teamwork is the dream work. Spoken like a real manager, right? Okay. This is 20 pages long, so let me get us queued up properly. I don't know how large this document is. Yeah, we got to make it bigger. My old lady eyes can't see something that small. All right. I got it, little drummer boy. You don't have to worry about emailing it to me because we are heading on down the road. Okay, so this was filed on July 2nd. Oh boy, this is from all of the O'Keefes. It's funny, Granny Debbie. I know how to pull court documents from certain courts that are very easy to navigate and get through. Florida seems to be a little easier than a lot of other states. But Massachusetts, that's a whole different ball of wax. And I have a full-time job, so yeah, I don't have time to be sitting and researching stuff. You know, I'm busy. I got people I got to take care of. Memorandum in support of plaintiff's motion to compel further answers to plaintiff John O'Keefe's II's first set of interrogatories to defendant Karen Reed. Here we go. Now comes relevant background. I'm not going to read all of that. Y'all don't want to listen to me drivel on about things we already know about. On March 17th, 2026, plaintiff John O'Keefe II served his first set of interrogatories upon defendant Karen Reed. Rather than providing substantive answers, Reed responded with baseless objections that the requested information is irrelevant, private, constitutes an improper fishing expedition, privileged, and is unduly burdensome. Well, let's see. We'll make up our own mind if we think it's those things or not. Counsel for plaintiff conferred with counsel for Reed on May 13th, 2026 to resolve this dispute without court intervention. Despite good faith efforts, the parties remain at an impasse. I'm shocked. Really? You couldn't get anything worked out? Imagine my surprise. Throughout the discovery process, Reed has engaged in a persistent pattern of discovery evasion and delay that has required court intervention and prejudiced plaintiffs' ability to prepare their case. Really? Projecting much here? On September 19th, 2025, plaintiff Paul O'Keefe, as personal representative of the estate of John Joseph O'Keefe III, served the estate's first set of interrogatories upon Reed. Responses were due by November 3rd, 2025, but Reed failed to respond timely. After plaintiffs served a final request for answers, Reed provided a vague, evasive, non-responsive answer, forcing plaintiffs to file a motion to compel for further answers. At defense counsel's request, plaintiffs agreed to hold their motion in abeyance and serve a rephrased supplemental interrogatory. Reed again provided an evasive response that failed to comply with the rules, ultimately forcing plaintiffs to file a motion to compel further answers. Plaintiffs now face the same problem yet again. Really? I must hydrate before I continue on. This is fascinating. This is like fiction. Okay. I don't think we need to read the legal standard. I think everybody knows when you are asked to provide discovery and such, you're supposed to do it. So let's see argument. Defendant Reed's objections to plaintiff John O'Keefe II's interrogatories are meritless and represent a continuation of her pattern of discovery obstruction in this litigation. The interrogatories submitted seek narrowly tailored information that is directly relevant to plaintiff's claims. Interrogatories number 1 and 2 and their corresponding answers are as follows. Interrogatory number 1, for a 2-year period before January 29th, 2022 through the present, please identify your primary care physician, including for each such physician, the date range which physician served as your primary care provider. Y'all, what is happening? Am I the only one that sees the hypocrisy here? Am I the only one? Am I alone in this? You want Karen Reed to give you all of her physicians' information and all of the physicians that she had for 2 years? But we're not supposed to talk about Michael Proctor being in the cuckoo house? What? What is happening? What is happening? I would not give that information. Ah! Heck no. No. I haven't even read the second answer. Let me continue on. I'm already outraged and I think there's more. I think there's more. Answer number 1, objection. Oh no, this is how they're answering in the outrage that I was feeling. Ms. Reed's medical health is not an issue in this action, and therefore she objects to this interrogatory on the grounds that it seeks information that is irrelevant and immaterial to the facts, issues, claims, and defenses in this action, and therefore outside the scope of discovery pursuant to Massachusetts Civil Code. Secondly, seeks medical information that is private in nature and is protected by state and federal law. And 3, is solely interposed for an improper and unwarranted fishing expedition that is intended to harass and burden her by seeking irrelevant information about which she has a reasonable expectation of privacy. Y'all. Shut the front door. Oh, why have I stayed away from the Karen Reed stuff? Well, I've stayed away from the Karen Reed stuff because they're nuts. Everybody's fighting with everybody else and attacking each other's YouTube channels, and I can't do it. I can't. I'd be like, I want out. Oh my goodness. And nobody seems to be going unscathed. So that's why I stayed away. Y'all know I don't do drama. I don't do it. Not gonna do it. But this is rather spicy. All right. Thank you so much for pointing or sending this to me, little drummer boy. I very much appreciate it. Interrogatory number 2. For each and every medication. What? What? For each and every medication, whether prescription or over the counter, that you were taking had been prescribed or had access to on January 28th, 29th, 2022, please answer the name of the medication, the dose and frequency of use, the date such medications were first prescribed or obtained by you, the condition or purpose for which such medication was prescribed or used, identify the prescribing physician or healthcare provider, identify the pharmacy where the medication was filled, and whether you took said medication on January 28th, 2022, and if so, the time and dosage taken. What? Wow. answer. Ms. Reed's medical health is not an issue in this action, and therefore she objects to this interrogatory on the grounds that it seeks information that is irrelevant and immaterial to the facts, issues, claims, and defenses in this action, and therefore outside the scope of discovery. Oh, yeah, I see y'all are popping off in the chat about it. Yeah, it's unbelievable what has been happening. Yeah, Ava, Danielle, stay away from the content creator drama and just follow Melanie or Emily to keep up on the court stuff. Yeah. I mean, and I'm happy that you're here because, I don't do drama. Nope. Makes me pukey feeling. Yeah, Granny Debbie, I think we've missed the plot. We've lost the plot. We have officially lost the plot. All righty. Seeks medical information that is private in nature and is protected by state and federal law and is solely interposed for an improper and unwarranted fishing expedition. And she has a right to privacy. Same thing. Reed's blanket refusal to provide any substantive response to interrogatories numbers 1 and 2 is legally unjustified. At the 9C meet and confer on May 13th, counsel for Karen Reed maintained the objections to interrogatories numbers 1 and 2 and refused to provide anything further regarding them. As demonstrated below, these interrogatories seek information that is directly relevant to the central issues in this case. But is it? Is it really central to the case? Is it? Because I think you have to prove that she actually hit him. Whether she was high on prescription medication, drunk off her tail, you're going to have to prove that she actually hit him. And I think that's going to be a problem. Reed's medical condition is directly at issue in this litigation. No, it's not. No, you are trying to completely drag her. That's what this is about. Reed's primary objections to interrogatories numbers 1 and 2 are that her medical health is not an issue and that the information sought is irrelevant, private and protected, and a fishing expedition. And each objection fails. First, Reed's relevance objection ignores the central theory of plaintiff's case. This wrongful death action arises from Reed's alleged. Technically, she was found not guilty of doing that. Alleged operation of a motor vehicle while impaired, causing John O'Keefe III's death. Plaintiffs must prove Reed's physical and mental condition on January 28th and 29th. This is unbelievable. Including her level of intoxication and any additional factors that may have enhanced her impairment. Well, didn't they, I don't know, didn't they do like a blood alcohol test? Why would you need to know 2 years worth of medical information? Let me ask y'all. If you were a drunk driver, do you think if they've taken, they did a sobriety, we're going to say, let's say Justin Timberlake, he got his nice little DUI. Do you think it's relevant for the court to go back 2 years to find out all of Justin Timberlake's medical records? Because that's what they're saying. She was driving impaired, so therefore we get to know everything that was going on with your medical history for 2 years prior to this incident. That's ridiculous. And it makes me sick. Hey, Kelly, thanks for joining us. And you're right, if you haven't hit the like or subscribe or any of that stuff, you need to do that. This is why my mod Kelly is my marvelous mod. Because she's the one that reminds all of you to do these things. I'm awful at it. All righty. Evidence of medications prescribed to Reed and or that she ingested on the night in question is directly relevant to establishing her state of mind, her physical condition, and her ability to operate a motor vehicle. Reed's own father expressed sufficient concern about the medications available to Reed that he told a 911 operator she needs to be in protective custody. She suffers from MS, boatload of pills because of her condition, and she could take an overdose. Yes. Yes. This statement, made in close temporal proximity to John O'Keefe III's death, demonstrates that Reed had access to significant quantities of medication. Plaintiffs are entitled to discover what those medications were and whether Reed ingested them on the night in question. Okay, well, I don't have a problem with that. I have a problem that you want to see 2 years worth. Second, Reed's privacy objection provides no legal basis for withholding discovery. Tell that to Michael Proctor and Judge Gildea. Is that how he says his name? I may have said it wrong. I don't know. He's the doofus, Your Honor. Judge Doofus. There is no absolute privilege barring discovery of medical information in civil litigation. The information sought in these interrogatories is reasonably calculated to lead to the discovery of admissible evidence. If Reed had legitimate privacy concerns, she could have sought a protective order under Rule 26C. Instead, she has provided plaintiffs with a blanket refusal. Yeah, I would provide you with a blanket refusal also. You don't need to see 2 years worth of my medical records. Go pound sand. Third, Reed's fishing expedition objection mischaracterizes plaintiffs' narrowly tailored requests. I don't think it's so narrow. I don't know why you need 2 years worth. Interrogatory number 1 seeks only the identity of her primary care physician from whom plaintiffs will seek medical records. Oh, yeah, of course, that's all. So we can go get all your medical records. Do they hear themselves? I mean, seriously. This request is basic information that parties routinely disclose in litigation. Okay. Interrogatory number 2 limits its request to the medications prescribed and or taken during a 48-hour period on January 28th, 29th, 2022. This very limited time frame does not constitute a fishing expedition. Yeah, it does. Rather, it is narrowly tailored to discover factors that may have affected Reed's impairment on the night of John O'Keefe III's death, which is directly at issue in this matter. I don't disagree with that's what's at issue, but not what she's consumed. Interrogatory number 3, for each purchase transaction you made on January 28th and 29th, please answer. Where is this coming from? Do they think she purchased drugs on those 2 days? The purchase transaction, identify the finance. So now we get to know all of her financial records too. Awesome. Type of account, account number, name in which the account was held, address of the financial institution or vendor, and the approximate date and time for each purchase or transaction. You got to be kidding me. The answer, yeah, I would object to that. Overbroad, unduly burdensome, and seeking information that is irrelevant and immaterial to the facts. I'm skipping a little bit. Subject to and without waiving these objections, and based on her current knowledge and recollection, Ms. Reed states that she had depository or credit accounts with the following banks and credit card companies during the time listed in this interrogatory: Bank of America and Barclays. Reed's response to interrogatory number 3 is equally deficient. Oh, blah, 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 blah. I can't read what their mess is. Reed's financial transaction records for a 48-hour period are discoverable and relevant to establishing her whereabouts and consumption. You can get that from the freaking Waterfall and C.F. McCarthy's. What do you need to get it from her? What? Yeah, again, too broad. Yeah, I don't know why you need to. You can get that from if you're concerned about how much she purchased, you can get that from the receipts from the two places that the two bars that they were. Why do you have to get it from her? Mm-mm-mm. Sorry, hydrating again because I've been so rageful this evening. Now they blah 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 about all the stuff they're upset over. I'm going to continue on. Requested relief. They're wanting all of this within 10 days. And respectfully requesting a hearing on the matter. Interesting. Let's see Exhibit A. And this must be the answer. Yeah. I'm just blown away. They will stop at nothing. The level of hatred that these people have for Karen Reed, God bless her. God bless her, because they hate her. They want to see her absolutely positively destroyed. Her having to sell her home, her having her losing her career, all of it, that is not enough. That's not enough. Not for these heifers. Let me tell you. Yeah. So I got some news yesterday. You may have remembered back when I was changing jobs and I had mentioned how it was such a cesspool, such an awful environment. My little team, great. Anything outside of my little team, awful. And I always had the feeling there was this mean girl mentality. Well, I got confirmation yesterday. See, I poached another one of the employees from my former employee. I have taken 3 since I left. And I'm happy to say that I've been a part of that. And I got confirmation there was absolutely an entire mean girl clique. And let me tell you, I know some of you watch from time to time. I am talking about you. I'm talking about you. You know who you are. And you can't help yourself because you, and this is how I feel. I feel like Karen Reed is being treated, or I'm being treated in the same way that Karen Reed is being treated, or I was treated that way. There's so much jealousy and hatred for an individual that has done nothing outwardly to you, and you can't let it go. You can't shut up about it, or I should say about her. You can't stop thinking about her. Nothing you do is enough to fill that void that you have in your life because you're the problem. Karen Reed isn't the problem, just like I'm not the problem with the mean girl society, the heifers at my former employer. You know how you are. I'm not the problem. Y'all are the problem because you can't stop watching me. You can't stop paying attention to me. You can't stop gossiping about me. That's what's going on with these lawsuits and these fixated individuals. That's what this is. It's unbelievable to see it played out in a legal manner, but that's what this is. I don't know why all the hatred, Granny Debbie. It's weird to me. Y'all, my hair's driving me crazy. I am getting my wig trimmed tomorrow. I can't wait. I am in desperate need of a trim on the wig. They do have a lot of skeletons in their closet. I think Colin likely has the most, and that's why they're working so hard to keep him protected. And yes, Kelly, you are absolutely correct. I stand corrected. I did save 3. Thankfully. And I know others have left. I didn't necessarily have anything to do with those others that left, but I know others have left. It ain't me. I'm not the problem. It's you. Look in the mirror. It's you. Alrighty, back to the... Oh gosh, what have I done? Was that where I don't think that's where I was. Yeah, I think it was. Okay. Here are the other part of the response here in answer. Yeah. 2-year period. They want all of her medical records because that's basically what that is. And then they want to know, in addition to all the medical records, what were all of her medications? And then the third is, while we're at it, you know, the 2 most private things in your life, your money and your health, let's just go ahead and throw that one in there too. Yeah, give us all your bank statements, all your credit card statements, everything. Everything. We want it all. Okay. You can get what you need for this case. You don't need to know how I spend my money in any other way. I think that's the last of it. Yeah. All of that information is available in other ways. There's no reason to make her provide it to you. You don't need to know, you know, where she bought her tampons. You don't need to know how many times she went grocery shopping in a week. You don't need to know about her Amazon purchases. Cut it out. Leave her alone. Go to CF McCarthy's, go to the waterfall, subpoena their receipt records, and it will all be there for you. It's not a problem. You know what time you have her on video. You know what time she purchased whatever alcoholic beverages she was drinking. And what are you going to do about the ones that John bought? I'm going to subpoena all those records too. You're going to provide all that in discovery? Just asking. Just, you know, inquiring minds would like to know. Yes, Granny Debbie. All that is in question is that night and that morning. I completely agree. Oh, let's see if I have anything of substance. I can't do the Proctor mess. And we already looked at the thumb drive. The Proctor mess is just, ugh. I can't. I just can't. Oh, let's see. This was the request by Karen Reed's team for what they wanted Michael Proctor to provide. This was requested on June 17th. So this is kind of in that same area. Let me see. Let me bebop a bit here. There was a hearing on 6/17. Let me see if I can get that pulled up. And we can watch this particular hearing because I think it got a little spicy. Let me get us caught up to the right spot. Okay, let's take a peek at another hearing because there was a lot of back and forth. And again, thank you very much to Mike Crawford and the Young Jerks for providing or allowing me to share this with all of you.
Good afternoon.
Good afternoon, Your Honor. Damon Seligson on behalf of Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Thomas Tang on behalf of Karen Reed.
Good afternoon. Who's going to argue on behalf of Ms. Reed?
Sorry.
Who's going to argue?
I am.
Can I see counsel at the side of the bench for a moment?
Oh, for God's sake. Already?
Start out with a question to the Reed. Attorney Rosenberg.
Yep.
In your opposition, you're basically saying the motion is moot because you responded to requests on May 21st, right?
As of filing that, yes, but I have an update that we
Hang
will
on.
have for you.
You go on to say in an email that's attached here, I should also point out, in the submission that you made, you pointed out to the clerk that some of the exhibits that you had submitted were not complete copies. So for the record is clear, you submitted complete copies of 3 exhibits that the court has substituted for what was in there because they weren't complete, correct?
Correct. I think that relates to the other motion, however. But yes, that's correct, Your Honor.
So in your, there's an email in there as well that you say there will be a future production.
That's the update I have for you.
Is it all produced?
Yes.
Do you agree?
To be clear, I can't give you a definitive yes or no, Your Honor.
When did you
That
get
was
it?
clear.
To the court's probably dismay, we were actually in a deposition this morning, which is nice to report. And
That wouldn't cause dismay.
yeah, I wasn't sure. I knew you might cause shock. I didn't know if dismay would come along with it. But that being said, Attorney Fell, my colleague, and I were in attendance for this morning's deposition, and Attorney Diller is unavailable at the moment. I received an email on or about 11:24 a.m. this morning from Ms. Reed's counsel acknowledging that a production to our supplemental request had been made. Following the completion of today's deposition, I got in the car and came here.
Let's not waste any more time
Yeah, I
on
can't
this.
confirm.
All right, you don't know, you just got it, you just sent it.
Our team, yes.
Your team.
Yeah.
Well, we'll use the collective.
All right, okay, yeah,
okay?
that's fair, Your
All
Honor.
right.
Yes.
All right, so let's move on. We're done with that for now. All right? Anyone
Yes,
need to be
ma'am.
heard any further?
Not at this time.
Do you need to be heard any further?
No, Your Honor, not on that motion.
Okay, so let's go to the next motion.
Yeah, let's.
And that's the motion relative
He'd never make it working for
to
me.
compelling
Come
Mr.
on.
Ballard. So, Attorney Rosenberg, and I guess to all the attorneys in this case and non-parties that are involved in the case, the pleadings I'm getting in this case, and I'm sure that I will get in the McCabe case, are replete with arguments presented as facts, which isn't really helpful to me. And there's a lot more background in these submissions than I really need to decide the issues. So I'm going to ask all of you, in the pleadings that you file, at least with me, just write what I need to know in order to decide the issue. And
Does this man not realize that this is part of making the record? Is this his first year practicing law? What? What in the blue blazes is happening? Y'all, you don't want to have argument in there? You don't want to have argument. Give me only the information. Shut up in my hearings. Speak only when I ask, when I want you to be spoken to. And write your motions so that they're not as complicated for me, because I don't like to read all that argument stuff. Is this man for real? Oh, I need this. I should have drank wine tonight. Holy cannoli.
Stop pandering to social media. All right?
Oh my word! I should have kept going. This man absolutely hates technology. He hates the internet. He hates social media. He hates all of us because of what we're doing. Wow. Oh, sir, I'm going to back you up saying that. We're going to listen to that again. Unbelievable. Unbelievable.
Just write what I need to know in order to decide the issue. And stop pandering to social media. All right? So now let's get on to your motion. And I have a question with respect to your motion that you wrote.
Can I just make one quick comment, Your Honor? Our memo, I agree with you, but our memo of law is 9 pages long, and it has a page and a half of argument. So we're not pandering to anyone, and we don't intend to.
You raised it, so let's talk about it. Let's go to page 3 of your motion, all right?
Oh, boy. Told you I thought this was spicy.
Top page, we don't have to restate the words, but end of the first sentence to the end of the second sentence. Excuse me, end of the first line, not to the end of the second line, all right? Now, how old was that individual when they went to the wedding?
I don't know, Your Honor, but...
So is it really, you don't know, so is it really, what if he was a ring bearer? Is that really relevant to the issue I have to decide?
Absolutely it is, because...
If a young child's a ring bearer at a wedding, okay, go to the line above there, okay, the words in quotes. Whose words are those? Because there's no reference, no citation to it, which makes it totally not helpful to me.
Understood, Your Honor, and that point is taken. However...
Well, who is it, do you know?
I believe it's her defense counsel.
Her defense counsel. You're citing a statement in quotes from your client's defense counsel. How is that relevant or appropriate, especially without citation?
But if I could take the first question first, and then I'll answer your second question. The first question, there's a significant relevance objection to Colin Albert being deposed or producing any documents in this case. You see it throughout the lengthy opposition.
I don't think the opposition is to producing any documents.
I would disagree with that, Your Honor, and I'm happy to explain why. But there's a significant relevance objection overall to Colin Albert being a
I know
deponent.
there's a relevance objection, but I don't think facts or claimed facts like that are really relevant. They're nothing but attempts to sensationalize certain. Let's go on to the real issue.
Your Honor,
no, let's go on to the real issue.
How is that sensationalizing it if it is the fact of what happened? Is this man really this dumb? Do you have to be dumb to be a judge in Massachusetts? No, because the judge in Brian Walsh's case was amazing. I loved her. She must have been one that slipped through the cracks. Because this guy's dumb. I was kind of reserving judgment before, but Judge Gildea, hey, Your Honor, you're dumb. And I am going to splash you on all social media that I possibly can because you don't want me to. And you tempted me with a good time. And so here we are, having a good time. I would be so frustrated if I were Rosenberg. I would be like, Your Honor, I'd like to make the record clear. Oh, I would lose my crap on this.
Your Honor, if you're going to point out that something is irrelevant, I'd like to please just very quickly address why I disagree with you.
I read everything. I know why you think it's relevant. You think it's relevant because they don't want to produce anything and they're trying to minimize the involvement. You're trying to do the opposite thing. I understand.
But you just told me you don't think it's relevant. I think I have the right to tell you why I disagree.
I don't need all that background, all right?
It's not background, Your Honor. It's a significant...
Oh my gosh, what is happening? What am I watching? I don't need all that background. Sir, how do you know what you need and what you don't need? Because you need to know what the correlation is between these people. What a jackwagon.
Let's move on.
Well, how is the relationship?
Let's move on.
How is the relationship between?
We're either going to move on or we're going to end the hearing.
Oh my word. He will not allow Rosenberg to make a record. I've not seen this before. Your Honor, you don't have the temperament to be a judge. You have to shut your mouth and let people make a record, whether you agree with it or not, or whether you want to listen to it or not. Oh my gosh, I'm going to have a heart attack tonight with this. Freaking Massachusetts. Oh my gosh.
Okay, well, Your Honor, I would note for the record, I'd like to address the point that you just made, referring to something as irrelevant, which I think is actually highly relevant. If you're not going to allow me to explain that in 2 sentences.
You don't know how old the person was at the time they attended the wedding.
Correct. But that doesn't impact the relevance. The relevance is the relationship between the families. That's the relevance, and that's the only reason it's referenced there. I don't think the fact that the families were close enough to attend weddings together is irrelevant to whether Mr. Albert is relevant to this case. But I'm happy to move on to your other question. I think, I don't know if you need an answer, but I take your point about quotation marks without a citation and the effectiveness of including prior statements of counsel and pleadings, and we'll keep that in mind.
Not helpful.
I feel like this judge wants to school everyone all the time. Go be a professor, Your Honor. Get out of the stinking courtroom because you're not interested in handling any kind of actual legal proceedings. What you're interested in is teaching people what you think is appropriate to be submitted. Got it. Got it.
Understood.
So now let's go on to some other questions I have about what happened here. Your office, not you individually.
Collective you.
Your collective you.
Yes.
Issued a notice of deposition on February 11th, 2026 for a deposition over 2 months later on April 29th, correct?
Correct.
Okay. And a subpoena was issued on April 15th.
Correct. Thereabouts.
No? Well, that's the date on it.
Okay, continue.
Compelling production of documents 12 days later on April 27th. And the subpoena was not served for 6 days. Would you agree with that?
If that's what it says, I don't dispute the general point you're making.
So my first question is there a reason that you would wait 2 months after issuing a notice of deposition to issue the subpoena?
Well, there were a lot of moving pieces schedule-wise, as you're aware, Your Honor.
No, the notice of deposition said the date of the deposition.
Understood, but obviously those change.
Why do you wait 2 months, less than 2 weeks, closer to 12 days?
Yo. This man will not allow Attorney Rosenberg to speak. I've never seen anything like it. I didn't think I could see someone in Massachusetts worse than Canoni. She's looking like a dream right now compared to this jackwagon. Oy, oy, oy.
To issue the subpoena and not serve it for 6 days.
Well, the service is dependent on the process server. I don't have an answer for you why it took 6 days.
No, it's not. The service is dependent upon the constable or whomever you hire to do it. Right?
Correct, Your Honor, but they're the ones that go out and
So
try to find
maybe don't wait until 2 weeks before the deposition.
Understood, Your Honor, and I don't disagree with you. But when that issue was raised,
the constable is a police officer.
Did anyone on our team say to Colin Albert's counsel, you have to get us those documents in the 8 days because that's what the subpoena says?
Well, that's what the document says. And I'm going to remind you of the provisions of Rule 45, which says a party or attorney, responsible for issuing and serving a subpoena must take reasonable steps to avoid imposing undue burden or expense on a person subject to the subpoena. This is a non-party. You served a subpoena asking for 4 years worth of information to be served in a very short period of time.
And that,
I don't think that's complying with either the words or the spirit of Rule 45.
and that's why, Your Honor, I don't have a problem with that, and that's why when that issue was raised.
Oh my
because
gosh, shut up!
There was a lot going on in the case, and it took longer to serve than probably we would have wanted it to. And so, Your Honor, when counsel raised that and said exactly what you just said, you've only given us 9 days to appear and 8 days to produce, whatever the specific numbers are, we said, we understand that. We are going to work with you on negotiating and conferring on the scope of the subpoena. And secondly, because of the time limit, we are going to reschedule the deposition so that we can resolve this document production issue, including when a production would be made, before the deposition, so that Mr. Albert doesn't have to come back twice. So I'm not fighting you on that, Your Honor. I agree. And when it was raised by Mr. Albert's counsel, they didn't get pushback on that, on the timing. And so I'm not defending that. It was an oversight, I think, and I would prefer that it had been served 30 days before.
With all due respect, to someone that's represented by 3 law firms and at least 10 attorneys, it's hard to envision that it was an oversight that the deposition of a non-party deposition subpoena doesn't go out until shortly before the deposition and 2 months after the notice of deposition.
Your Honor, frankly, there's no basis for that. There's nothing intentional that has been done here. I agree with you. It should have been done sooner, and I apologize that it was not done sooner.
Attorney Rosenberg.
And when it was raised by counsel, there was no pushback.
Get him.
On that. And I think if you ask counsel, they will confirm that there was not pushback on the timing.
Let's skip down a ways to April and May. And am I correct?
Your Honor, you're the one that wanted to critique the motion page by page. So here we are. Here we are. Good for Attorney Rosenberg. Stick to your guns. He is far calmer than I could ever be. Yes, the good Lord knew what he was doing when I did not go to law school to become an attorney, because I would have absolutely lost my ever-loving mind in this courtroom with this man. Because when someone doesn't allow me to talk, when I'm trying to make a record, it gets... Y'all are here tonight and we're watching this idiot judge because he said for me and other content creators and people on social media to shut up and stop doing what we were doing. Yeah, don't tell me to shut up. No. I will make your ears bleed.
Correct that your office knew of Mr. Albert's availability and unavailability in the month of June. Were you made aware of it?
When?
Were you made aware of it by Attorney Touchberry?
When? At what point? Eventually, on, I believe, May 20th? The email is an exhibit.
May 20th. So,
and May 20th, just to be clear, the explanation that we received was between now, May 20th, and June 2nd, Mr. Albert is available. We proposed, I believe it was May 27th and May 28th. After that point, Mr. Albert will be unavailable indefinitely without an explanation. Frankly, the first explanation that we received was in the motion, or in the opposition to the motion.
and
So, yes.
I know you call into question the manner in which Mr. Albert's deposition was noticed by the plaintiff's attorney, and I'm not arguing with that. But am I correct that you had notice of that deposition?
Were we aware that the plaintiffs planned to proceed with their deposition? Yes.
Yes. And even if the notice may have been deficient, as you reference in your pleadings, you or your team, like you like to refer to it, made an intentional decision not to appear without coming to the court at all.
So, first of all,
that's a yes or no question.
Well, I don't think it is a yes or no question, Your Honor.
Right.
We were aware, and we didn't file a motion. But again, I'd like to address why that is, if you're going to raise the issue. May I address that?
I know why you didn't, because you claim you wrote about it, why you didn't. It's in there, I read it.
Well, if you're asking about it at the hearing, I'd like to address the point.
Right.
So what happened was we served the subpoena. As you say, we have a team of lawyers. different lawyers are taking different depositions. The lawyer that's taking the deposition drafts, serves, and prepares the subpoena and prepares for the deposition. We did all of that. We complied with the rules with your exception about date and timing is taken, well taken, and it won't happen in the future. However, otherwise, the subpoena was fully compliant with the rules, and the rules require us to be able to take the deposition. We didn't say it has to happen on this exact date. What we said was we will reschedule it to another date. The recipient of a deposition subpoena doesn't get to choose when the deposition happens by playing games like were played here and are laid out in our papers. Mr. Albert's counsel was notified in this back and forth in the emails that are attached to the motion papers that the attorney who was prepared to take Colin Albert's deposition was going to be away on 2 particular days that they had proposed. That one of those days, 6 days later, is the one that the plaintiffs chose. So the attorney who had prepared was not available, as was told to Mr. Albert's counsel.
That's why they picked that day.
As you referred to, was issued in direct violation of Rule 30b-1. So we provided notice to all parties that we believed that deposition could not go forward pursuant to that notice, and we continue to believe that. But if the question is, did we come file a motion for protective order? No, because we don't believe we needed to.
Attorney Tuxbury.
Yes, Your Honor.
When is Mr. Albert going to be produced for deposition?
Never.
He appeared for that deposition on the 28th pursuant to subpoena, and then he is.
Hang on, let's lay the groundwork.
Yeah.
You agree you accepted a deposition subpoena?
He was served a deposition subpoena for April 29th.
And you talked about taking it off. Didn't go forward. When's he going to be available?
At this point in time, Your Honor, I'm not sure. It'll be sometime in the fall. It'll be sometime in the fall. He's got 10 weeks training.
Not going to happen.
He's in basic training right now. We have 1 hour of communication with him.
I don't dispute what you're telling me, but I'm not going to.
How convenient.
On a statement report that a witness can't be produced until the fall. So go find out when he can be produced before that.
Okay, I will, Your Honor. Try. We won't be able to talk to him until Saturday. I'll talk to him Saturday briefly and see what we can figure out.
Well, it's not a matter of figuring it out. It's a matter of you saying to him, there's a duly issued subpoena. As I said in one of my pleadings, in this case, which you weren't involved in, a subpoena needs to mean something. Just as an attorney agreeing to continue needs to mean something. And it shouldn't end up in front of me in these circumstances.
I appreciate that, Your Honor. We're in a situation where we learned on the 20th, and we let them know the same day. I know they say there's games here. We informed them the same day that we found out this information, that he had been accepted into the military and had a shipment date of June 2nd. We said, please take his deposition during this period of time. I know you want to take it. And at that point in time,
watch Karen. She is.
Put aside the fact that you represent him in another case.
Certainly.
That was a call that was filed not that long ago.
She knows that's a lie.
Certainly, maybe a party that's going to prosecute an action such as they have alleged should stay in touch with their attorneys and let them know what's going on.
Certainly. And we know what he's going through his first 3 weeks school. And then when this
we don't care.
10 weeks basic training. We're not sure where that will be.
Why is he listening to all this drivel? He couldn't even stand to listen to an argument or Attorney Rosenberg putting anything on the record. But boy, he'll hear all about Colin Albert's basic training schedule. Why aren't you shutting him down and telling him, I don't need to know all that. Produce him, make the deposition happen. Subpoenas matter. Yeah, but subpoenas don't matter in Massachusetts. They don't matter there.
The Army will assign him that location of where his 10 weeks of basic training will be. He'll be on, like I was saying, Your Honor, he'll be on leave in the fall. So in terms of I appreciate
get your butt there.
Make it clear. We're not waiting till the fall.
Okay.
All right. Discovery ends.
That's what they're counting on.
August 17th.
Okay.
So you're going to go find out when he can get back up here and be deposed.
Okay.
Now let's talk about the status of any discussions between the attorneys as to the scope of the production. I agree with Attorney Tuxbury that the scope of the subpoena is excessively broad. I know there have been discussions, but I don't know where you're at now. Have you had any recent discussions?
No, the discussions are what are laid out. And if Your Honor is inclined to ask us to, we can continue to work on the document side and report back to you in a few days. Great.
Yes, I mean, we made our proposal, Your Honor, with respect to, issues about what this case is about, which is the death of Officer O'Keefe on the night of January 29, 2022. He searched for all communication with law enforcement for the entire period of time and looked for other ones. We never heard back. We got this motion in response to that. I mean, we're happy to look at other stuff here, but I think to your point, the asking for private conversations, communications, really from our perspective is a non-starter without being tied to this case.
To you, Attorney Rosenberg, collectively, let's keep in mind, okay, that I know there's the other case, but you're talking about a non-party.
But understood, Your Honor, and I don't know if you would want to, but I'm happy to get some thoughts from you about because what Mr. Tuxbury is referring to is the extremely narrow two categories that they said we'll search for these and we don't have any documents. We search and we don't have any documents other than the text chain that's already public record. So I think that is certainly too narrow. But I also take your point to me that as it stands, the subpoena is too broad. There is obviously, as you are aware, Your Honor, there's more than wrongful death alleged here. The false narrative is part of the claims the plaintiffs have brought in this case, and that obviously relates to much longer than January 28th and 29th, 2022. So to the extent, A, there's burden.
I don't know that it extends 4 years.
And I'm not trying to argue it because I don't understand that you want to decide that as a fact right now. All I'm saying is it's broader, and this is kind of my point. I think it's broader than what Mr. Tuxbury and his team interpret it. You're telling us that you think it's narrower than what we interpret it, and that's taken, which is why I suggested we have a conversation about maybe meeting somewhere in the middle, and I'm fine doing that.
When can you have the conversation?
Tomorrow?
Sure. Yeah, I'm open to a call anytime. Just call me. I'm available tomorrow afternoon. We have a meeting for something else tomorrow afternoon. It's like,
Not me that has to call you.
I understand. It's anyone. Damon can call me. I never know who.
The whole I'm open to a call, all you have to do is just call me. All you have to do is just call me. Gives me former boss vibes. Well, Janet, the phone works two ways. You can call me anytime. Sir, I haven't heard from you in 3 months and you're my boss. Don't you think that's odd? Am I supposed to call you all the time? Because, yeah, that's not normal. Like, I see my boss all the time. Now, not back then. I would see my boss maybe twice a year where I used to work. Yeah, no, I saw my boss today, as a matter of fact. I saw him twice. Saw him in the morning, and then I saw him again in the afternoon. Guess what? I'm going to be in an all-day, multiple meetings with him tomorrow, too. It's crazy. I see my boss all the time. Not the last one. He's like, oh, I don't have time to be doing my job and, like, talking and helping you achieve success. Oh, that's way out of my pay grade. Oh, who is Damon? What am I missing? And yes, I believe he was desperate joining the Army. He's hoping he'll get through this and that the deadline will pass and he'll be in the clear. I don't know. I'm super anxious to find out what the answers are in the deposition. Damon is the bald attorny. Gotcha. All right, we'll continue on.
You have to call me because there's allocation of attorneys, so you have to know who you're talking to. But yeah, I can have a conversation about that. But obviously, as you know, this is a wrongful death case with there's an intentional infliction claim based on a false narrative. In many respects, that false narrative claim is the other side of the coin of the wrongful death, right? If she has said things that someone else did it, and they show she actually did it, a priori, false narrative. It's not the defamation case. This is not the harassment case, the criminal harassment case that's proceeding with respect to Mr. Carney in Norfolk County. And so we're happy to consult with them and look for more stuff. I think there's a disconnect because there's a different view of what happened here. And
Ew,
so
little
I think
drummer
they're
boy.
frustrated when we say we don't have any documents because he simply doesn't have any. He searched. We're willing to consider searching for more and expand the time scope of that search, but in likelihood the answer's going to be the same.
I understand you stand before me representing a non-party.
Yes.
But we're all aware of the other case in which certain allegations have been made. So you're going to have to do some of those searches sooner or later.
Of course, Your Honor. I think what I'm just trying to do, I think, following the guidance of this court, this case is the wrongful death case. We're going to do discovery, and we're doing discovery in the defamation case, and we're going to get document requests, I'm sure, that will be broader than that. That's a different case here. And so the issue I have, Your Honor, as a third party here in this matter, is resource issues, right? It's quite expensive here. We're going to have to do this in the defamation case.
We don't care
That's
how
going to be
much it
different and
costs
separate
you.
apart from this one. So
What?
all I'm trying
Sir, y'all brought this case. We don't care how much it costs you, and nobody in this courtroom should care how much it costs you. What are we talking about now? What are we talking about?
do, Your Honor, is kind of ensure that not needlessly harassing a third party here in this action. I appreciate what you're saying, Your Honor. We're going to produce those documents in response to the RFPs when we get.
If he would just appear for the deposition, there'd be no harassing. It would be done and everybody would move on. Why are you so stupid and can't figure that out?
That, right? Obviously we are. We've already gotten one set of RFPs for Ms. Reed in that case too. So I do appreciate it. I'm standing here as a third party, subject to the protected Rule 45
third party.
in this matter. And my client in this,
Not
in this
acting like
instance
it.
is also a party to a defamation case originally filed in Barnstable County, now appearing before Your Honor. But I think in terms of like the scope of discovery and forcing him to kind of like do duplicative discovery, that's a little excessively burdensome. And so I think it's appropriate to keep our focus on what they want for this case. Yeah, like I mentioned before, it's not before Your Honor. We had thought that consolidation for discovery purposes might make sense to avoid this kind of situation, and it was rejected. That's fine. I'm not asking to address it. But
I don't think the hospitality defendants would really want to do it.
I will tell you, Your Honor, they actually said okay. I'm not to speak for them, but they said okay to it. But that's these issues that I'm dealing with, Your Honor. I appreciate what you're saying with respect to the defamation case and discovery in that matter too. But that's why here, I think the appropriate scope for this case is, as you've laid out before, which is what happened to Officer O'Keefe on that night. And on that point, as we put out in our
wasn't hit by a
briefing,
car.
Tom Albert simply doesn't have a lot to say.
He's just going to start arguing on
Yeah, we'll consider Bert. No,
What depositions are scheduled for Monday? I should know because I asked you for the
He
calendar.
doesn't have much to say. Well, then it should have been a quick deposition. What are we doing?
Oh, Monday is
Ugh.
Nicole Albert, but that's going to be that's a subject of a separate motion to compel that's pending via 9A.
Oh, look who's
filed
there.
hopefully early
Snaggletooth
next week.
herself.
Great, so hate to ruin your weekend, but you and your team can review what you got today, and the two of you can talk. We can all come back Monday afternoon at 3 o'clock, talk about this again. Does that work for everyone?
When you said your team, were you talking to Mr. Buck? Okay. Let me just make sure.
Zoom or in person, Your Honor?
In person.
Perfect.
Yes, that works.
I will not be available, Your Honor. I think I mentioned this at our Rule 16 conference. I'll be gone for a while.
Maybe you have someone that could report on the results of your discussions.
Certainly, I can do that, Your Honor, and that's part of the issue with respect to resources. Obviously, I have my colleague Kieran Murphy, who's here with me, pro-hopped into the defamation case. It costs money to do that.
We don't
it's not
care
cheap.
about
So I can
the
try to
money.
find someone in my office to respond, or he can respond without appearing before Your Honor, and then we can figure out.
We have no objection to making that easier, however we can.
Say that again?
To the extent there's a way that Mr. Murphy can appear, we're fine with it.
But we'll let him appear. Right?
Yes, I mean, I'd asked today. I understand that he's not pro-hopped into this case. That's all.
We have no.
Don't tell anyone, okay?
We'll keep it a
Enjoy your
secret.
vacation. After you talk to Attorney Rosenberg.
Yes.
Anything else? call. You have other motions that are coming?
Yeah, we do. We have a motion to compel that's coming.
I bet you
again,
do.
next week. I think the opposition's due early next week. Be filed with you shortly. There's one pending motion from the plaintiffs, I believe, seeking additional information in response to interrogatories. That's it, I think.
At the moment, I believe that's accurate.
Okay, well, see if you can agree amongst yourselves as to a date to have another hearing the week of June 29th on those motions. Well, soon to be filed, all right? You don't need to do it right now. All right?
Oh, no.
Anything else?
No.
Can we address one topic at sidebar briefly, Your Honor? Thank you.
Side notes, y'all. Side note. Sorry, whew, that white noise is something else now, isn't it? I don't know how Karen keeps it together. She has way more forensic decorum than I have. I do not have the forensic decorum required to sit in Judge Gildea's courtroom. Yeah. Hey, Snaggletooth. Why you there? All you're doing is stirring the pot. Who's the doofus next to her? Who is that next to her? That's not her husband. Oh, Chris Albert. I was going to say, he looks very familiar to me, but I wasn't able to place him. I've removed myself from this sort of craziness. So, yeah, let me see. We still have all that going on. That might have been the end of the hearing. Oh, let's see.
Record a bunch of video that we're posting on our YouTube.
We have next Monday.
That's
and
right,
after
the
that, we
pizza
have
owner.
9:45 on the 26th for a status.
That's still by Zoom, Your Honor?
Yes.
Okay.
All right. Thank you very much.
Thank you, Your Honor.
See you on Monday.
That's it.
Score. All right.
Oh, boy. I did not expect to get so worked up about this. I mean, I knew I was torqued about Judge Gildea and all of his shenanigans. But wow. Oh. Mediocre chicken parm? Oh, have you gone to Chris Albert's? What is that place called? C&E, right? Isn't that what that place is called? Sad that I know all of these restaurants and everything. Well, none of them look like they're Italian. So I don't know why they would have any kind of good Italian food. I wouldn't expect. I would think in that neck of the woods, there are actually a lot of D&E, not C&E. C&E was a little party store where I used to live in Tennessee. D&E. Thank you for correcting me, Camper for Life. Yeah, I'm shocked by that. Well, I don't know if you all noticed or saw, I added the Massachusetts mess docket back to my upcoming dates that I sent out on Sunday. That had a lot of new updates in it because there's been some movement in several different cases. Let me consult my cell phone where I keep all of this information. I did see, as long as we're kind of that's all the things I was going to cover. Thank you so much for pointing me in the direction of the motion regarding the interrogatories. That was phenomenal. Thank you so much. But let's do a recap on what's coming up. Thanks, little drummer boy. Have a great evening. Thanks again. Barry Morphew had a hearing on Monday. In that hearing, I think they're finally starting to solidify a trial date. Did y'all hear what this trial date is? July of 2027. A year from now. We have to still follow this stupid putz. So that's still coming up. There was a David Anthony Burke status hearing. I have not dug into that yet, as well as today there was an Antonio Brown hearing and John Paul Miller hearing. I haven't had an opportunity to dig and see what I can find out about that, but whatever I find out as far as any new dates or anything, I always post it on Sundays. I post it on YouTube here, on TikTok, and also on the Twix, so that everyone can see what's coming up in the next several weeks. There's supposed to be another Karen Reed hearing on Friday. We'll see what happens on that one. There was a lot of stuff going on this week. Courtney Clenny is supposed to have a hearing tomorrow. Shayna Gardner has a pre-trial hearing tomorrow. And Terrion Arnold is supposed to have a hearing on Friday as well. So there's a lot happening just this week. And then right next week, on Monday, Sarah Grace Patrick. On Tuesday, get ready for this. Tuesday is Karen Reed, Brad Simpson, Joseph Duggar, and John Paul Miller. They start jury selection in his trial. And depending on how my schedule works out and depending on how long that trial is, if it is available on Law and Crime or Court TV, we're probably going to do a rewatch of that trial, since I did that deep dive just a couple weeks ago. And Kelsey Fitzsimmons has a pretrial hearing next week. And then Karen Reed, as far as I can see, has 2 hearings next week. So that's kind of the status update for just the next 2 weeks. It's crazy town out there. I do want to say, I think, let me check something while I have the chance right now. Well, it looks like it was seen now, but I have not gotten a response. So I had an odd message that was sent to me on the Twix, and it was an individual from Attorney Ahmad Cruz's office that reached out to me. They wanted to speak with me. Well, they were telling me that Attorney Cruz wanted to speak with me with reference to the Edric Faust case. I don't know what it is all about. Keep making sure that you're following me with the notifications and such, because I would love to talk to Attorney Cruz. I would love to talk to our Mr. Bowtie Bates. And I'm also really wanting an answer in the Zachary Adams case, but I digress. So I am hoping that I can connect with Attorney Cruz. I would love to do that. If that happens, obviously I'll send notifications and we'll get together on here to chitty chat with him. What else? Granny is asking, Joseph Duggar, where will he be in person in Panama City? I do not know. I have every intention over the next couple days to be reaching out to Attorney Saulene, who is representing him in the Panama City Beach case. And I'm hoping I can get some details maybe about that. I know I can't get ins and outs as to the actual what's going on with the case, obviously, but maybe I can get some intel on some timing or what it looks like as far as discovery is going. Again, none of the specifics, but just more about logistics about that, because that should be close enough to where I live. It's driving distance that I can go. So that may be one of the cases that I end up taking some vacation time and going and sitting in court. So stay tuned because we got stuff coming. I think that is all I have as far as kind of getting you all up to speed on everything. Thank you so much for hanging out. If you haven't left your DNA on the like button, you need to do that now. And tell your friends, family, anyone else that wants to come and hang out and learn about some true crime. I have absolutely, at this point, no idea what I'm going to cover next week for Wine and Crime Wednesday. And it's going to start closing in on my rehearsal schedule. And so I may end up having to do weekend live streams. So just make sure you have the notifications turned on or that you're following me on X. I always put on X when I'm going to be going live. I do that usually about 24 hours ahead of time. I'm there. And of course, if you pay attention on YouTube, then you would get a notification when I have one scheduled. But I don't know for sure what I'm going to be doing next week. And as soon as my show is, once we get past opening night, I'm probably going to go back to at least 2 nights a week that I do live streams. We'll go back to the Monday Matters and also Wine and Crime Wednesday. And we'll see what we can cook up. Oh, Granny Debbie? Granny Debbie says she's an hour away and would love to be there if he's in person. Added bonus to meet you. Well, thank you. Yes, Granny Debbie, it would be wonderful. Yeah, I am, fingers crossed. I still have so many things in the hopper as far as guests and things that I want to try to iron out and have on here to talk about different things. So stay tuned. There's still lots to come. It seems like crime is never done. You all know how it is. And I can't wait for tomorrow to get my wig trimmed. I'm like battling it tonight bad. But I hope you all have had a lovely week up to this point. Thank you to my marvelous mod, Kelly, for joining. And thank you to all of you, all my regular chickadees, for hanging out in the coop with me this evening. And you out on the Twix, thank you. And my replay crew, I love that you always let me know when you're my replay crew. So keep doing that. I appreciate each and every one of you. Thank you seems so small, but I do want to say thank you again. And remember, it doesn't cost a penny to be kind. So find someone to do something nice for today if you haven't already. And remember,